Hi, this is Andrea Kane, and I'm here with you for HIT 421. And we are now on week 4. We'll be studying chapters 6 and 7 in your textbook this week. This lecture is going to be on chapter 6. We will be looking at unit objectives 9.3.1 through 9.3.14. If you want to turn to page 97 in your book, we'll go ahead and get started. A couple things I want to say about this chapter. Please read through it really carefully. Make sure that you understand the information that's in here. A lot of it is a little bit complex and complicated, but I have confidence in you that you will get it and understand it. I also want to point out to you that all of the terms that are in bright blue in your book, those are the ones that you really need to be memorizing and making sure you understand. So whether you use flashcards or Quizlet or you write things down in notes, make sure that you focus on those blue terms. And if you're a little bit confused by what's in the book, take a look at the glossary in the back of your book. Sometimes it gives a slightly different definition that may help refine your understanding of that term based on between what's in the book and what's in the glossary. All right, so if you want to follow along, chapter 6 starts on page 97, and we're going to be talking about torts. Torts are a civil wrong. This means that we're not talking criminal, we're talking civil. When we were talking criminal, remember it's the state that acts as the plaintiff. They're going after a defendant, and they're doing it because it was a crime. So they're doing it for the point of punishment. Now let's step away from all of that and into the civil realm. In the civil realm, you have an individual who feels they have been wronged. They are the plaintiff. They and their attorneys bring the case against the person that they feel did the wrong, which would be the defendant, and their goal is to obtain damages from that defendant, usually monetary in nature, as compensation for the wrong that was committed. Now, we're not talking necessarily crime, because remember, that's all on the criminal side, that's all the state. We're talking about the civil side. And when you think about the criminal side, you've got the state that's the plaintiff, and their job is to punish the defendant if they're found guilty. And they do that with beyond a reasonable doubt in proving their case. When you look at the civil side of life, you've got the plaintiff and their attorneys bringing the case against the defendant. They're saying that something wrong was done, not criminal, but wrong, or something should have been done that wasn't. But anyway, what happened is there was some type of injury. Whether that is emotional or actual, there has to be some kind of injury there. And they're trying to get monetary damages for what happened. And they're looking at a preponderance of evidence, or they're looking to see that it was so obvious that it's clear this wrong was committed by the defendant and therefore damages should be assessed. So do you see the difference between those two? You have to keep that in mind. Everything criminal needs to be blocked out as we enter the world of torts, because torts are a civil wrong. You've already had the term liability. This is a legal obligation or responsibility by a party in a lawsuit. This one should be new to you. It's tortfeasor. That's a person who commits a tort. So tortfeasor is essentially the defendant in this case. And most healthcare lawsuits are based on torts. And if you look at your book, you can see we're going to be talking about all sorts of things. We're going to start out by talking about the types of torts. Then we're going to talk about degrees and elements and defenses and all of these other pieces and parts that go with torts. So it could get a little bit confusing. You may want to write these down to try and separate them in your mind. Torts, as we talked about, this is a wrong. It's a wrong that could have been committed against a person, which is often what medical malpractice is, personal property, or real property. Torts can be classified as intentional, unintentional, or strict liability. Unintentional is also known as negligence. So make sure you know that. Let's talk about intentional torts first. There are 4 basic types of intentional torts: assault, battery, false imprisonment, and emotional distress. So battery is where someone intentionally touches someone else without their consent. Assault is where someone is actually almost attacking, or it's like they're going to attack. What the conduct is it causes apprehension. So assault is, I think someone's coming at me to harm me. Battery is, they actually touch me and I feel it's harmful. And then false imprisonment is where you are confining someone against that person's will. Now, assault, battery, and false imprisonment are also crimes, right? They're also crimes, but they can also be torts. They can also be pursued by the plaintiff as a tort on the civil side of life. So don't be confused. Assault, battery, and false imprisonment, absolutely they are crimes, and the state will prosecute those. And they will do it, again, to inflict a punishment upon the person that does them if they are proven guilty. But on the civil side, they can also be pursued as a civil case by the plaintiff and their attorneys to obtain some damages because it happened. Now, the 4th type of intentional tort is infliction of emotional distress. This is where someone does something that results in extreme distress. It doesn't result in an injury. It doesn't result in causing fear or an actual injury that someone can point to or that type of thing. This is the emotional distress, and it's a lot harder to prove in some cases. So intentional torts, assault, battery, false imprisonment, emotional distress. Defenses to this include the plaintiff consented, said it was okay, the relationship permitted it, or it was necessary for self-defense. And I'm not going to go into all those. I mean, they make sense if you think about them. Whether they're true or not, that could be a whole different story. But those are the typical defenses that defendants and their attorneys use when they are in an intentional tort case. Now let's move on to unintentional torts, also known as negligence. Make sure you have that clear in your mind. Anytime you see the word negligence, it's unintentional tort. This is where someone's conduct of acting or failing to act as a reasonably prudent person would resulted in harm or injury to another. This is based on a standard of care, what an individual is expected to do or not do in a particular situation. And negligence is the basis for most medical malpractice cases, but you do have some that are based on intentional tort. And you can have some that are both. You can have negligent infliction of emotional distress. So keep that in mind. Emotional distress can kind of go in both categories, both intentional torts and unintentional torts. So the types of negligence. You have nonfeasance, where someone didn't do something they were supposed to do. You have misfeasance where they did do what they were supposed to do, but they did it improperly, and that caused a problem. And then malfeasance is where they did something, but what they did, that could very well have been unlawful. So again, nonfeasance was they didn't perform an act that they should have and should have known to do, and an injury resulted or some type of damage resulted. Then you have misfeasance. That's where they did perform the act that was expected or should have been or needed, but they didn't do it right. So you can see how standard of care plays into that in all of these, because standard of care is you do these things. Standard of care is here's how you do them, and standard of care is these are things that everybody knows to do that are appropriate to care. They're not unlawful. So that's why it's so important for healthcare professionals to follow standard of care. And that impacts us also as HIM professionals. We need to follow our standard of care, which is to follow the HIPAA laws, to make sure that nothing is improperly disclosed, to make sure we watch what we say or write so that we don't disclose things that we shouldn't in sort of an invasion of privacy issue. So coming back to here, we've got these types of negligence. Make sure you know what each of them is and how they work. Degrees of negligence. You can have ordinary negligence, which is, it's just an ordinary level, or you can have extreme negligence. This is where somebody not only went off the path, but they went beyond it. And whatever they did caused something extreme, because what they did was almost to the point of recklessness. So you have ordinary negligence, ordinary unintentional tort, or you have gross, extreme, reckless, unintentional tort negligence. In order to prove negligence, there are some elements you have to have. So let's go into them. There's 4. Duty to care. There had to be an established sort of relationship or expectation of a relationship, in that the defendant had to care for the plaintiff. There has to be a duty there. So for instance, a patient showing up in the ED establishes a duty of care because the hospital is there to provide care, and by showing up and seeking care, there's been that establishment of a relationship with a duty of care. There has to be proven a breach of duty, that the person didn't do something they were supposed to do. They did that, but they did it wrong, or they did something so extreme it was reckless. Any of those 3 are that breach of duty. It's the last slide. I'm sorry. It's this slide right here, types of negligence. That's under that breach of duty. Injury. There has to be an injury. There has to be some type of damage. There has to be some type of harm that was actually caused, whether that is emotional distress or something particular, such as, let's say, a surgeon performed, a surgeon was to perform a left mastectomy on the patient for breast cancer, but instead left the left breast and performed a right breast mastectomy, which was not part of the agreement, not part of the procedure, and the right breast had no cancer in it, that sort of thing. That shows you a breach of duty and the injury. There was an injury that resulted from it. Many people like to file lawsuits, and I know this from years of being in risk management, and at one point I had my licensure from the state of Florida as a risk manager, and there were lots of people who could prove the duty of care, could even prove a breach of duty, but they couldn't prove an injury, a real injury, and so therefore their case was tossed. You have to be able to prove that injury. If you don't have an injury, you can't move forward with a case. Then the last piece of this is you have to prove causation. There has to be some type of cause between what the defendant did or didn't do and what happened, resulting in the injury. So that causation can be actual, or it can be proximate, that it was clearly foreseeable that what they did or didn't do would have caused it, or would have resulted in the injury. So as a plaintiff in a negligence tort case, you have to prove those four elements in order to win your case. Damages. These compensate the plaintiff for physical and monetary injuries. And there's a couple of types of damages. You can have nominal, which is basically nothing. It recognizes wrongdoing, but there's no money there. There's compensatory, where you look at what did the plaintiff lose as a result of their injury. Is that economic, non-economic, that type of thing, and they get compensated for that? Or is it punitive, that what the doctor did was so bad, or what the hospital did was so egregious, so awful, so reckless, that they add these punitive damages to punish them, and so in the hope that they never ever do this again to someone else. The plaintiff generally has that burden of proof to prove all the elements of negligence. Now, let's go back. They generally have that burden of proof where they have to use the preponderance of evidence, okay? Generally. The exception is this lovely Latin phrase, res ipsa loquitur. The thing speaks for itself. Res ipsa loquitur. The thing speaks for itself. This is when it's just so clearly obvious. I gave you the example of the surgeon who left the left breast with the breast cancer in it and took the right breast instead. That is just so obvious. That is just, it speaks for itself. I mean, it's just so wrong. There's no way you could look at that and say that it was defensible. There's just no way. I mean, there's just no way. So that's an example of where there's not a whole lot of burden of proof that's needed to get the judgment of negligence. Some things are just so severe, so obvious, so horrible that they are what they are. So I'll let you read through the rest of that. Defenses. How do you defend yourself, or how does your hospital defend itself when there's a negligence case? Well, one thing they can do is try to prove contributory negligence, that the plaintiff contributed in part to the injury. So let's say that I want to think of a case, and I'm coming up blank here. But let's say that a doctor gave instructions to the patient, and they were supposed to follow these instructions. And maybe the doctor should have followed up with the patient and done, some other test or treatment or what have you, but the patient was responsible for these instructions, and if the patient didn't follow the instructions, it would result in an injury. That is an example of contributory negligence if that plaintiff didn't follow those instructions and ended up with the injury. Okay, that makes sense, because if the plaintiff didn't do what they were supposed to do and that caused the injury, then why are they blaming the defendant? The plaintiff had a role in what happened, and so that's contributory negligence. Comparative negligence is where you look at how much of a percentage of negligence did the plaintiff had that contributed to the injury. So let's use that example again. The doctor said should have done some things, didn't do it, but gave instructions to the patient. The patient didn't do that. The injury resulted. Then they're trying to figure out, is it 50% doctor, 50% plaintiff? Is it 75 doctor, 25 patient? Is it 75 patient, 25 doctor? That's where they're getting into all of this. But if they can show that the plaintiff contributed in any way to their injury, that helps the defense. Assumption of risk. This is one that is often at the base of consent to treat forms and procedure consent forms. If you're going to go in and you're going to have a major surgery, you have to sign an authorization or a consent form for this procedure. And part of that is it mandates that the surgeon go over with you the risks, benefits, and alternatives to the surgery. And having written hospital consent forms multiple times, I'm very familiar with this information. You have to have areas in there where the doctor goes over with the patient and says, here's the procedure I think you need, and here's why I think you need this procedure. Here are the benefits of this procedure, but here are the risks of this procedure, and they have to list them out up to and including death. This is all risks that you may take. You may risk a stroke. You may risk being disabled. You may risk paralysis. You may risk all of these things. So that's the risks. Alternatives. Okay, if we don't do this procedure, here are the alternatives. Is there a different procedure we could do? Is there a lesser procedure? Is there something altogether different? You list out the alternatives, and sometimes there aren't any. Sometimes they've got to have the procedure or it's death. And they lay that out there. And sometimes they say, okay, you've got to have this procedure versus not having this procedure and dying. But if you have this procedure, you're going to risk that you may still die. You may have significant side effects. For instance, you may be paralyzed and bedridden, or you may have brain death, or you may have whatever it is. And then at the end, they ask the patient, okay, we've gone over all these things. Do you voluntarily agree that you want to move forward? And that's what a consent to treat or consent for surgery is all about. Risks, benefits, alternatives. You've got to lay all those out for the patient, and they have to voluntarily sign that they understand what you're saying and they want to move forward. Because without that, the plaintiff can say, I didn't know that there was a danger of paralysis. I didn't know there was a danger of stroke. I didn't know that there was a danger of XYZ. Or I didn't realize that the risk of having this procedure meant that I could I could have loss of blood flow to my limb and have to have an amputation, a subsequent amputation. There's all these things that have to be laid out. And if you can prove that they were laid out in advance, then the plaintiff can't recover on a negligence claim. But they can if they say, I didn't know, you didn't tell me about any of the risks, or I was forced into this. So that's a defense. That's why you see consent for treatment and consent for surgery forms. It's not always the best defense, but it's a good, it says here not usually a good defense, and I would argue that because I have seen cases where a good consent form completely filled out by the surgeon and documented and witnessed has saved a provider. I've seen that. So I would argue with this last thing on the slide. I would say it's not the best defense, but it can in the end save a provider. It really can. Particularly in the couple of cases I saw where they had a witness and everything was laid out very clearly. Very. So yes, patients do seek medical care out of need, but if it's laid out for them, it's clear they have alternatives. And that's it. I mean, they've got alternatives and they're choosing this alternative. That's voluntary. Other defenses: sudden emergency doctrine, unavoidable accident, act of God, rescue doctrine. I'm going to refer you to your book for these, and they are on page Where are they? I saw them not long ago. Yes, page 106. Page 106 in your book. So look at those terms there. Charitable immunity was eliminated as a way to protect hospitals from liability after the Illinois Supreme Court case in 1965 of Darling versus Charleston Memorial Community Hospital. You have an assignment on that this week, so please make sure that you take a look at that. I'm not going to cover it here. If you have any questions, you can always look that up on the internet as well for some more information, because that's a classic. It's an absolute classic case. Prior to this, hospitals were pretty much immune from liability, and afterwards it opened wide open, and you saw a lot of hospitals being dragged into cases. And here's why. Plaintiffs' attorneys know that doctors have money, but who has the bigger pocket? The hospital does. Most hospitals have over $100 million in reserves, and they have to have that in order to keep them open and no matter what happens to them. And plaintiffs' attorneys know hospitals have these reserves. I've worked in hospitals that have had over $200 million in reserve, and between their investments and their accounts and all sorts of other stuff. Attorneys know this, and they will go after the hospital and pull them in. So, and not that that's a bad thing, because the hospital does need to be responsible for what happens in their facility and for the people they hire, the people that they credential, the people that they contract, all of that. The hospital is responsible for them, and they should be. So it's not that this case was bad, but it opens some doors that have been very interesting, I would say, from having been inside and seen the litigation over many years. So corporate negligence, and then you have respondeat superior or vicarious liability. These are also on page 106 in your book. I would ask you to read through those. They'll make more sense if you look up the Darling case first. So I would suggest that when you get to this slide here, if you haven't already, at least Google the case and read through it so that you're familiar with the basics of it, and then move on, because then it'll make a lot more sense about corporate negligence. And the third type of tort is strict liability, and this is liability without fault. It applies liability for loss due to one's acts or omissions regardless of fault. Whether or not they're at fault, they're liable. So they're gonna do that. An example of this might be that it happens on the property owned by someone, that the injury happens on a property that's owned by someone. They're liable because it's their property. Even though they didn't cause the injury, they're still liable. So that's where strict liability comes in. And this would be like abnormally dangerous activities or product liability cases, where let's say that there was a device that misperformed, and although the plaintiff may go after the doctor that performed the procedure in the hospital, the company that provided the device may also be included, and they may find themselves dealing with strict liability because if they knew that their product was defective, they hid it, that sort of thing, then they're going to be strictly liable, because it won't matter whether or not it's their fault, they're involved. So moving on to improper disclosure of health information, and this starts on page 108 in your book. And I think it would be helpful to you to read through your book before you watch this video, but especially for disclosure of health information. But having said that, here we are, so we'll go ahead together. All right, defamation of character. This is where someone falsely communicates about a person to another and it harms the person's reputation. It can be done verbally, which is slander, or it can be done in written form, which is called libel. And in order to prove defamation of character, you have to prove that the defendant made a false and defamatory statement about the plaintiff, that the statement was not privileged, that the statement was published or made public, that the conduct of the person who did the defamation was negligence or intentional. Okay, was either unintentional or intentional. So it can't be just strict liability. It has to be one of the, negligence or intentional tort. There have to be actual or presumed damages that resulted. So those things have to be proven in order to win a defamation of character case. Defamation is usually thought to be intentional. Okay, so with this, there's an element of intentionality. It can be negligent. It does say here it can be negligent, but I would say most of the time this is going to be intentional. There are some defenses. You can argue it's the truth, but even that is probably not going to hold for you, because if it wasn't, if you don't have authorization to disclose it, you're looking at more of an intentionality there. A defense can be privileged that the communication was made in good faith at an appropriate time and manner to those who had a legitimate reason to receive the communication. We talked about privileged relationships. Then we talked about how doctor-patient, pastor-parishioner, husband-wife, those types of psychologist-patient, those types of relationships. So that can be a defense. If the person authorized you to disclose the information, then that's a defense. And if you didn't publicize it to anyone, then that's a defense as well. Because remember, here, to prove it, there has to be some type of publishing. There has to be some type of making it public to someone else who's not involved. So if you don't do that, then that is your defense. Invasion of privacy, and this is another one that I think personally has a bit of intentionality to it. You're intruding upon someone's right against unwarranted publicity and exposure. You don't have a right to take what you find out and make it public. So elements of invasion of privacy: you had a duty not to invade someone's privacy, meaning their confidential medical information, or PHI. You breached that duty, and there have been some damages from that breach. So those are the elements of an invasion of privacy case. And that's why I said there's got to be some intentionality here, because if you have a duty and you breach that duty, there might be some intentionality there. To defend yourself, you would need patient authorization, or you'd need to claim that privileged relationship, or you'd have to have a waiver in that the patient themselves already made those facts public. So what you did didn't matter, so to speak. Unfortunately, and I think this is very wrong, courts have made exceptions in cases of public figures and individuals in newsworthy situations, and I think that's appalling. I think everyone has a right to their privacy. I'm one of those people that personally thinks that someone who is a public figure or a celebrity, that if they're out at a restaurant, they shouldn't be bothered. They shouldn't have their photograph taken. They shouldn't be approached by people. I think that they have a right to their privacy, to live their lives as an individual person, which any of the rest of us would prefer. It's one thing going up to see, you see a friend sitting outside at a restaurant, and it's one thing to go up and say hi. It's a totally different thing with public figures and celebrities. They may be there with their family or friends, and to me, it's intrusive. Now, that's a personal opinion, and obviously the courts haven't shared that. But I think that just because something is newsworthy doesn't mean that someone's rights should be trampled. Unfortunately, like I said, I don't make the rules. Breach of confidentiality. Unauthorized disclosure of a person's private information. Now, breaches can be intentional. They can also be unintentional. This can be where someone accidentally faxes something to the wrong fax number, or where someone provides a copy, they're printing stuff off, they grab it up, it's got some other information on it that belongs to a different patient, and it ends up getting released, or something like that. Breaches are based on fiduciary duty, meaning that you have an obligation to act in another person's best interests due to a special relationship of trust, confidence, responsibility. And that is us. That is us in the health information field. We have an obligation to act in everyone's best interests. Every patient's best interest, I should say, not everyone's, but the patient's best interest due to a special relationship of trust, confidence, responsibility. We are the keepers of the records. We are the keepers of the information. It's up to us to protect it. We release it when we have the right to do so or the obligation to do so. Outside of that, we are the protectors. And so I feel really strongly about this. I feel that every individual has the right to have their information cared for as if they are our loved ones, because they are someone's loved one, and they have the right to privacy. They have the right to that respect. But anyway, getting back to the topic at hand, there are 3 elements here when you prove a breach of confidentiality tort, and that is existence of a duty not to disclose health information, meaning that, we have a duty not to disclose it. If we breach that duty and damages were caused. Again, you can have a duty and you can breach that duty as if there were no damages, then there can be no case. There have to be damages. There are some defenses to breach of confidentiality, and they're same as invasion of privacy. Now it brings in emotional distress. This is an improper disclosure caused emotional harm or injury. And what they're trying to prove is that the defendant negligently, recklessly, or intentionally engaged in extreme and outrageous conduct. The defendant should have realized that his conduct involved an unreasonable risk of causing the distress, and from the facts known, the defendant should have realized that the distress might result in illness or bodily harm. So an example would be some people who have had access to PHI have sold it to tabloids and gotten quite a bit of money for it. They've also gotten sued and probably had to give up all that money and perhaps a little bit more. But that's what they're proving. They're required to prove that the conduct involved an unreasonable risk, and that based on the information that was released, the distress might have resulted in some type of damage or harm or injury. So negligence is improper disclosure, and you just go through a simple negligence inquiry. Malpractice statutes, every state has some type of malpractice statutes in them. And some states actually go so far as to talk about wrongful disclosure. Then there's liability for improper disclosure that can result from federal law, like HIPAA. So you have, the point here is, we were talking about civil law, and that can be brought to bear with improper disclosure of health information. But there can also be criminal law, because you're dealing with HIPAA and federal and state privacy laws. And there have been crimes attached to improper disclosure. So if someone decided to do that, they could find themselves not only facing the civil side through the tort, but they may find themselves facing the criminal side through federal and or state criminal law. Immunity from liability. Immunity protects certain persons or groups from tort. It's not based on lack of wrongdoing. It's based on status or position of defendant. So, for instance, they give you the Good Samaritan statutes that if somebody stops and they help and something happens, they have some immunity from liability because they did it in good faith or they did it to try and help and mitigate the situation. And that's where you get some of the whistleblower type protections. Statute of limitations, and this is on page 112 in your book. There are statutory enactments that place time limits on certain claims. The reason is that it allows injured people reasonable time to bring an action for recovery and allows claims to be resolved while evidence is still available and fresh. So that's the balance they're trying to reach. They want to give it long enough that a person can say, oh, this happened, but they don't want it to be so long that the evidence is no longer available or fresh or all of that. So that's the balance on the statute of limitations. The period begins to run when the act or omission is complete and at the time of the last exposure for ongoing injury. The period of limitation can be suspended or tolled for reasons such as the injury was reasonably not discovered, the injured individual dies and the executor sues, the removal of the individual's disability, maybe it reverses or it heals, the tortfeasor concealed wrongdoing, or the minor reaches the age of majority. So what that means is in these cases, the statute of limitations can be extended, so to speak, until something has changed significantly. And they give you those examples. Statute of repose means the maximum time in which a lawsuit can be brought. So let's choose the minor one because that's a really good one. A minor may have 7 years after they reach the age of majority. And age of majority is typically 21. So let's say that it might be a birth injury or something that happened congenitally. That individual has until they are 28 years of age to bring their case. After that, it's over. If it didn't happen in that 7 years after they reach the age of majority, then the window ends. So that's one example of where it would involve a minor. And that 7-year time period is based on state law. It's whatever your particular state says. But the total 28 years, that would be the statute of repose. That would be that maximum time. And the period of limitation would be the last 7 years where they've now reached the age of majority and they can choose to bring the suit if their parents did not when they were a minor. Hopefully that makes sense. Contracts versus torts. And this is on page 114. A contract is an agreement, and that's not part of contract law. And we'll see that as we move into chapter 7 and talk about that, but that's really not a part of what we're doing here. I'm going to leave this to your book to talk about. There's just one tiny paragraph at the top of page 114, and you can read through it. I think it makes sense. And it'll make even more sense when we get into talking about contract law next chapter. So going back to criminal liability in healthcare, wrongdoing in healthcare context generally leads to civil liability, but you can have criminal penalties, and it brings up HIPAA, antitrust, fraud. Those are examples where it's going to cross from civil into criminal, and you can have both. Medical malpractice insurance is there to protect professionals against medical malpractice lawsuits, and every provider has to have it. They just do. And you can have a lawsuit brought against you and settle it and not have done anything wrong, but simply chose to settle it because of the cost of taking it all the way to trial to exonerate yourself. I know many healthcare providers where that was the case, where they didn't do anything wrong. They really didn't even breach their duty. But because of the case and all the money and the cost that goes into it, they just chose to settle with a nominal amount outside of court rather than pursue it all the way. And most providers do that over their career, and that's what their insurance is there for. So if you look up any provider and you see that they've made settlements, it's not necessarily a reflection on them. One of the most sued medical professions is OBGYNs. And I have worked with many throughout my career. And most of them are phenomenal. The vast majority of them are phenomenal. But you will get patients who refuse to do what the doctor's recommending, and then something goes wrong. I'll give an example like shoulder dystocia. There are babies that are born that can be 10 pounds or more. And based on the mom's anatomy, there's not a really good chance for that baby to come through without the risk of shoulder dystocia. And doctors will talk to the moms, and some moms will absolutely insist, I'm going to have a vaginal delivery. It doesn't matter what you say. I've seen it documented. The doctors are trying to say this is a risk to a vaginal delivery. The size of your baby, what we're estimating it at, that is a risk to a vaginal delivery, and you may want to consider a C-section. And you will have moms that absolutely insist, I have to have a natural birth. I'm not having any kind of anesthesia. I'm not having any kind of procedures or anything like that. And then the baby comes out, there's shoulder dystocia, and the mom is furious over what happened and sues the doc that delivered the baby. Even though you've got all of this information, she and her attorney are going to try and take it all the way up to get money for what happened. The doctor may not have done anything wrong, may have done everything right. And I have seen this more than once, and still get sued. Most of the time they will settle out of court because it's a lot less expensive to settle out of court than it is to pay their attorney and go all the way through to prove that they were right. And that is what our medical malpractice world has turned into. So there are some tort reform measures that have been enacted to control costs and perceived injustices associated with tort claims. And I have a discussion question on that for you to do some research and to think about. And then here's a list of types of tort reform measures. And you will find that if you study tort medical malpractice cases across the world, the United States is pretty extreme in how it has evolved with medical malpractice cases, and why tort reform might very well need to continue here in the United States. So I would challenge you to take a look at that with your discussion this week. And then you also have an assignment on liability scenarios. All right, that's it for Chapter 6. I'm sorry it went really long. We didn't have that many slides, but there was lots of information to cover. I'll be back soon to talk to you about Chapter 7. Take care.